I was finishing dinner at Ryan's house when my phone vibrated against the oak table. It was just after 7. Emily had made roast chicken. Ryan was talking about supply chains, margins, and expansion capital. I had been listening, nodding, saying very little. The screen showed Laura Clark. Laura does not call casually. In 22 years of living next door to me, she has only called when something required clarity. I answered. "Tom," she whispered, her voice thin and strained, "are you selling your house?" I kept my expression neutral. "No. I'm staying with Ryan for a few months. The house isn't on the market." There was a pause long enough for the air in the room to change. "Then why," she said carefully, "are movers emptying your garage?" Ryan stopped speaking mid-sentence. Emily's fork hovered above her plate. I did not react. "What truck?" I asked. "White. No logo." "They've already taken your tool chest." "And the cedar cabinet from Helen's workshop." "Helen's cabinet." I stood slowly, placing my napkin beside my plate. "Stay inside," Laura added. "Something feels wrong." "I'll handle it," I replied, and ended the call. Silence settled over the dining room. Ryan cleared his throat. "Everything okay, Dad?" "You tell me," I said calmly. Emily looked at him before answering. That glance lasted less than a second, but it was enough. "Dad," Ryan began carefully, "we were going to talk to you." "When?" I asked. Emily stepped in. "You've been overwhelmed. We didn't want to stress you." I looked at my son, then at his wife. "Who authorized movers at my house?" Ryan inhaled through his nose. "We did." "We?" "The power of attorney," he said. "You signed it." I felt no anger. Only confirmation. 2 years ago, after Helen passed, Ryan insisted I move in with them, temporarily. He said the stairs in my house were dangerous. Said I needed company. Said grief makes people isolated and vulnerable. He was right about grief. Wrong about vulnerability. During those first months, he brought paperwork for me to sign. Just tax adjustments. Utility transfers. Insurance confirmations. I remember the afternoon clearly now. I was sitting at this same table. Emily stood behind Ryan, watching. I signed without reading line by line. I trusted my son. That trust was the first asset they liquidated. "Bring me the document," I said. Ryan hesitated. "Now." He returned with a folder. Inside was a durable general power of attorney granting full financial authority, including real property transactions. My signature appeared at the bottom. The formatting was inconsistent. The statutory language was outdated. The notarization incomplete. It was either incompetently drafted or deliberately rushed. "When did you execute a listing agreement?" I asked. Emily answered. 3 weeks ago. "And the deposit?" Ryan looked down. "It's in our joint account." "It's temporary." Temporary. The same word he used when I left my home. "How much?" I asked. $780,000, Emily said. "And the buyer?" "Private investor." "Cash." "Of course." I picked up my keys. "Where are you going?" Ryan asked. "To verify," I replied. The drive to my house took 28 minutes. I spent them reconstructing timelines in my head. When did they begin planning this? When did Emily suggest it? When did Ryan decide my consent was optional? When I pulled into my driveway, the garage door was open. 2 men were wrapping my belongings in moving blankets. Inside the house, a woman in heels walked through my living room, photographing walls and fixtures. I entered without announcing myself. The real estate agent turned. "You must be Mr. Harris." "We were told." "You were told incorrectly." One mover handed me a contract. My name. A signature resembling mine. But it was wrong. The pen pressure inconsistent. The slope misaligned. I know my handwriting. This was a forgery. "Stop," I said quietly. The agent stepped outside to call her broker. The movers froze mid-task. I walked through my house slowly. Family photos stacked near the door. Inventory sheets on the counter. Helen's cabinet halfway wrapped. Prepared for removal. Prepared for transfer. I stood in the center of the room and felt something settle into place. They believed I was declining. That was their mistake. When I returned to Ryan's house, they were waiting. "You embarrassed us," Emily said immediately. "I prevented a felony," I replied. Ryan's composure was thinner now. "Dad, this is practical. That house is too much for you. The money would help us expand the business." There it was. Not safety. Not concern. Liquidity. "You moved the deposit into your personal account," I said. "That's not estate planning. That's conversion." "You signed authority," Emily insisted. "I signed something," I answered. What I did not sign was permission to strip me of my property. Ryan's jaw tightened. "You forget things." "I remember enough." The room went quiet. "I'm meeting with Daniel Brooks in the morning," I said. "Our lawyer?" Emily asked, alarm slipping into her voice. "My lawyer," I corrected. And in that moment, when fear flickered across her face, I knew this was no longer about family. It was about evidence. And I had just begged *N collecting it. Daniel Brooks did not look surprised when I placed the power of attorney on his desk. He adjusted his glasses, read the first page, then the second. He did not interrupt. He did not comment. He simply absorbed. When he finished, he folded his hands. "Tom," he said evenly, "did you ever intend to give your son authority to sell your house?" "No." "Did you ever discuss transferring ownership?" "No." He nodded once. "The document is defective." "How?" "The statutory reference is outdated. The witness signature is incomplete. And this notarization would not survive scrutiny. It was either drafted poorly or rushed." "Or both," I said. He looked at me carefully. "Has the house been listed?" "Not publicly." "Private investor. Cash offer. Deposit already transferred." "To whose account?" "Ryan and Emily's joint business account." Daniel leaned back slowly. "That complicates things." I assumed it would. He opened a legal pad and began writing. "First, we freeze the transaction. I'll file notice with the title company and send formal objection to the brokerage. Second, we demand accounting of all transferred funds. Third, we examine whether this rises to fraud." "It does," I said calmly. He studied me. "Are you prepared for what that means?" "Yes." Because I was. What Ryan and Emily did not understand was that I had spent 32 years in commercial oversight and compliance. I built audit frameworks for multinational vendors. I understand paper trails. I understand leverage. And I understand timing. Daniel made 3 calls while I sat there. Title company. Brokerage compliance department. County recorder's office. By noon, the closing had been formally flagged. By 1, the buyer had been notified of pending authority dispute. By 2, the agent who walked through my house the day before was under internal review. Momentum matters. When you move first, you define the narrative. That evening, Ryan called. His voice was tight. You involved a lawyer? Yes. You froze the sale? Yes. You're making this bigger than it needs to be. It was already big. Emily took the phone. Tom, this is embarrassing. We've already committed part of the deposit to expansion costs. Committed? I asked. Equipment orders, she said. Supplier agreements. With funds that were not yours. Silence. You signed the POA, she insisted again. I signed a document you presented as administrative. You executed a sale you did not disclose. Those are different things. Ryan came back on the line. We were protecting you. From what? From being alone. From mismanaging assets. I've managed assets larger than your entire business valuation, I replied evenly. He exhaled sharply. Dad, why are you doing this? Because I am not confused. The line went dead. The following morning, I drove back to my house. The moving truck was gone. The garage stood open. Inside, my tool chest sat near the door, partially reloaded. They had reversed enough to avoid obvious criminal exposure. Not all of it. I walked through each room methodically. Inventory sheets were still in the trash. One was signed by the agent. That was useful. In the kitchen, I found something else. A folder tucked beneath a stack of counter brochures. Inside were printed marketing sheets, my house listed as, coming soon, private transition opportunity. With interior photographs taken without my knowledge. Time-stamped. 3 weeks ago. While I was living under my son's roof. Planning without disclosure. That was not impatience. That was strategy. I photographed everything. Front and back. I documented the garage inventory list. I photographed the forged signature. Then I drove to the bank. The branch manager, a woman named Carla Jensen, had known me for years. When I requested a full transactional audit of all accounts associated with the power of attorney, she hesitated only briefly. Within 20 minutes, we had printed 6 months of statements. The deposit, $78,000 earnest money, had been wired into Ryan and Emily's business account. Within 48 hours, $31,000 had been transferred to a supplier in Nevada. Another $14,000 to equipment leasing. The rest remained. They had not expected interruption. I requested immediate freeze of any further disbursement tied to the transaction. Carla complied. You're within your rights, she said quietly. I knew. That afternoon, Daniel called. It escalated, he said. How? Ryan contacted the brokerage claiming you're cognitively declining. He attempted to assert that you're being manipulated. I paused. By whom? By me. Of course. Control the narrative. Reframe the father as unstable. Classic deflection. Daniel continued. I've already countered with formal affidavit of competency and requested medical evaluation if necessary. But understand this, they're positioning you as impaired. I absorbed that calmly. Good, I said. Good? Yes. It forces transparency. Because once competence is examined formally, it becomes documented. And documentation, when clean, becomes armor. That evening, Ryan arrived at my house unannounced. He stood in the doorway, jaw tight. You're tearing this family apart. No, I said. You did. You're making it public. You involve third parties first. Emily followed him in. You don't understand the pressure we're under, she said. Explain it. Ryan hesitated. The truth arrived slowly. The business expansion had not been optional. They had over-leveraged. Credit lines stretched. Inventory miscalculated. The deposit from my house was intended to stabilize liquidity before creditors pressed. You were going to replace it after expansion, Ryan said. With what? He didn't answer. You risked my house to cover your miscalculations. It was temporary. Temporary theft is still theft. Emily's composure cracked. We're your family. Yes, I said quietly. And that's why this is worse. Ryan stepped forward. What are you going to do? I'm going to protect my property. And us? I cannot protect people who are willing to sign my name without permission. The room went still. He understood then. This was not an argument. This was a boundary. The next morning, Daniel filed preliminary civil notice for fraud and improper execution of power of attorney. He did not file criminal charges. Not yet. But the framework was in place. Title freeze. Financial hold. Formal notice. And a court hearing date scheduled within 3 weeks. Ryan called that afternoon. His voice was smaller. Dad, can we resolve this privately? We will, I said. In court. Silence. You'd really do that to your own son? I answered calmly. You did it to your own father first. When people prepare for battle emotionally, they make noise. When they prepare strategically, they become quiet. I chose quiet. After the preliminary filing, I reduced all direct communication with Ryan to written channels. No calls. No hallway confrontations. No reactive exchanges. Every message documented. Every statement preserved. Documentation is leverage. Daniel and I met twice a week. We dissected the power of attorney line by line. The drafting inconsistencies were glaring. The statutory citation referenced a version of the state code amended 3 years earlier. The witness signature belonged to a paralegal who had no record of notarizing it. The notary stamp was valid, but the commission date did not align with the execution date. Sloppy. Or rushed under pressure. Either way, indefensible. We subpoenaed the notary's logbook. There was no entry for my document. Forgery now had structure. Next, we examined the transfer trail. The $78,000 deposit had moved quickly, but not invisibly. Bank metadata reveals more than most people understand. Device IDs. IP addresses. Authorization timestamps. The wire originated from Ryan's office computer. Not mine. He could not claim confusion. Emily attempted to shift the narrative publicly. Through extended family, she implied I was isolating myself. That grief had progressed into instability. That they were trying to help. I did not respond. Silence, when clean, becomes credibility. Instead, I scheduled a full independent cognitive evaluation with my primary physician. Not because I doubted myself. Because I wanted the record. The results were predictable. No impairment. No decline. High executive function. The report was sealed, notarized, and filed as evidentiary support. Armor. Then we turned to the business. Ryan's expansion numbers did not add up. Daniel's forensic accountant examined publicly filed supplier contracts and leasing obligations. The company had extended credit beyond projected revenue. If liquidity did not stabilize within 90 days, creditors would begin collection proceedings. My house was not a gift. It was collateral. When confronted with pressure, people justify entitlement. Ryan convinced himself he was borrowing. Emily convinced herself it was strategic timing. Neither understood fiduciary duty. Daniel advised we escalate leverage before the hearing. I agreed. We filed motion to compel full accounting of all funds transferred under the POA authority. We requested business financial disclosure to determine intent. If they argued misjudgment rather than fraud, financial records would clarify. Pressure applied evenly. 2 days later, Ryan requested mediation. "Let's fix this before court," he said in a written message. The tone had changed. Less accusation. More calculation. I agreed to mediation on one condition: full financial transparency prior to session. They hesitated. Then complied. The disclosures revealed what I suspected. Personal credit cards near max capacity. Business loan extensions pending. Supplier penalties accruing. They were not malicious masterminds. They were desperate. Desperation does not excuse theft. But it explains acceleration. I studied the numbers alone that evening in my living room. The same room where Helen once kept meticulous household ledgers. I felt something then. Not rage. Not betrayal. Clarity. Ryan had crossed a line not because he hated me. Because he believed I would absorb the loss quietly. That assumption required correction. The mediation session was scheduled for Friday morning in Daniel's office. Neutral room. Recorded. Witnessed. Ryan arrived first. Emily followed 10 minutes later. They did not sit beside me. The mediator outlined the process. I spoke only when necessary. Daniel presented the deficiencies in the power of attorney execution. The absent notary log. The forged signature analysis. The financial trail. The deposit transfer sequence. Ryan attempted explanation. He said he thought the POA was broad enough. He said I had verbally agreed months ago to consider selling. He said expansion would have benefited everyone. Emily added that market timing was critical. I listened. Then I placed the cognitive evaluation report on the table. The mediator read it carefully. Then I placed the bank audit summary beside it. Then the notary subpoena response. Then the forensic signature comparison. Paper is louder than anger. Ryan's posture shifted. Emily stopped speaking. I made one statement. You may have convinced yourselves this was temporary. But you signed my name without permission, transferred my property without disclosure, and positioned me as cognitively unstable to protect yourselves. That is not assistance. That is fraud. Silence. The mediator asked what resolution I sought. I answered precisely. Full reversal of sale. Immediate return of all transferred funds. Revocation of power of attorney. Written admission of improper execution. Business reimbursement schedule for supplier losses not tied to my deposit. And a formal boundary: no future financial authority without independent counsel present. Ryan stared at the table. Emily's jaw tightened. They requested private caucus. 30 minutes later, they returned. They agreed to most terms. Not all. They resisted written admission. Daniel leaned forward. Then we proceed to hearing, he said evenly. He did not raise his voice. He did not threaten. He simply stated trajectory. Emily's composure fractured. You're going to destroy us, she said to me. No, I replied calmly. You nearly destroyed yourselves. Ryan finally spoke. We'll sign. The agreement was drafted over the next 72 hours. Precise language. Clear restitution schedule. Immediate wire return of remaining deposit funds. Formal revocation and public record filing. They signed. But paper alone is not exposure. Exposure requires consequence. Daniel advised one more step. We filed a formal correction with the county recorder noting attempted improper conveyance. Not to punish. To protect title integrity. The record would show dispute history. Future buyers would ask questions. Reputation has weight. That weight now rested where it belonged. After signing, Ryan asked to speak privately. We stood in the hallway outside Daniel's office. You didn't have to go this far, he said. Yes, I replied. I did. He looked at me differently then. Not as father. As boundary. I thought you'd understand, he said quietly. I understand perfectly, I answered. You thought I wouldn't act. He had no reply. That night, I returned to my house. The garage was orderly again. Helen's cabinet stood untouched. The living room quiet. I walked through each room slowly. Nothing missing. Nothing sold. Nothing transferred. I sat at the kitchen table and drafted one final document. A living trust. Property shielded. Authority structured. Independent fiduciary appointed. Not Ryan. Not Emily. Professional oversight. Experience teaches once. It rarely needs to teach twice. The hearing was scheduled for a Tuesday morning at 9 a.m. By then, the mediation agreement had been signed and most funds returned. On paper, the matter could have ended quietly. The sale was voided. The power of attorney revoked. Restitution underway. But there was still the court filing. And once something enters the public record, silence is no longer an option. Daniel advised we proceed. Withdraw now, he said, and it becomes a private dispute. Continue, and the record reflects attempted improper conveyance and misuse of fiduciary authority. That protects you long term. Protection matters more than comfort. We proceeded. Ryan and Emily arrived separately. Their attorney sat between them, posture rigid. He had reviewed the mediation agreement and likely advised them to settle fully before the hearing. They had chosen partial compliance instead. The judge entered promptly at 9. Efficient. Unemotional. Focused. Daniel presented the case concisely. Improper execution of power of attorney. Unauthorized property transfer attempt. Deposit conversion to non-beneficiary accounts. Representation of cognitive decline without medical basis. He did not embellish. He did not dramatize. He presented documentation. The judge read the notary log discrepancy first. Then the forensic signature comparison. Then the bank audit trail. Then my cognitive evaluation. She looked at Ryan. Did you obtain independent legal counsel for your father before executing property transfer authority? Ryan swallowed. No, Your Honor. Did you disclose the sale to him prior to initiating closing procedures? No. Did you transfer deposit funds into your personal business account? Yes. There are moments when narrative collapses. That was one of them. Emily attempted to speak. The judge raised her hand. Answer the question directly. Emily stopped. Daniel then introduced the mediation agreement and partial restitution. The judge reviewed it carefully. Why, she asked Ryan, was this not resolved prior to court? Ryan's attorney responded carefully. Emotions escalated. Family misunderstanding. The judge did not smile. This is not a misunderstanding. This is breach of fiduciary responsibility. Silence expanded in the courtroom. Then the ruling. The court formally voided the attempted conveyance. Declared the power of attorney invalid due to improper execution. Ordered full restitution of all transferred funds within 14 days. Issued formal finding of improper fiduciary conduct. And, more importantly, entered the matter into public record as a cautionary order regarding misuse of delegated authority. No criminal charges. But no ambiguity. Reputation adjusted permanently. Outside the courtroom, reporters were not present. But attorneys talk. Title companies review public filings. Financial institutions monitor fiduciary disputes. Within 48 hours, Ryan's primary supplier contacted him requesting updated financial assurances. Within a week, their equipment leasing company reduced credit terms. Consequences do not shout. They accumulate. Emily sent one final message that evening. "You've destroyed our credibility." I responded once. "You did that yourself." No further exchange was necessary. 14 days later, the final restitution wire cleared. Daniel confirmed receipt. The record was closed. But I did not return to normal routines. Protection requires permanence. I transferred the house into the newly established trust. Independent corporate trustee. Dual signature requirement for any future sale. Explicit revocation of familial financial authority. Then I revised my will. Ryan remained a beneficiary, but conditional. Structured distributions. No lump sums. No unilateral control. Experience informs architecture. 3 weeks after the hearing, Ryan came to my house alone. He stood in the doorway longer than usual. The arrogance had dissolved. What remained was something closer to recognition. "I underestimated you," he said. "Yes," I replied. He stepped inside. We did not sit at the kitchen table. We stood. "You could have pressed charges," he said. "Yes." "Why didn't you?" "Because exposure was sufficient." He nodded slowly. "I thought you were slipping," he admitted. "Repeating stories. Forgetting details." "I repeated stories because you were no longer listening." Silence. Then something unexpected. "I was scared," he said quietly. "The business was collapsing. I didn't know how to fix it. And you chose my house as leverage." He lowered his eyes. "Yes." I studied him carefully. Not with anger. With assessment. Fear explains behavior. It does not excuse it. "I will not finance your fear," I said calmly. He nodded again. "I understand." Whether he did or not was no longer my responsibility. Emily never returned to the house. Through extended family, I heard versions of the story recirculated, softened narratives of miscommunication, overreaction, generational tension. I did not correct them. The court record speaks more clearly than gossip. 6 months later, I hosted a small dinner in my own dining room. Laura Clark attended. Daniel and his wife. 2 neighbors. Nothing elaborate. Just controlled company in a house that remained mine. At one point, Laura touched the cedar cabinet gently. "Glad this stayed where it belongs," she said. "So am I," I replied. After they left, I walked through the house alone. The floors creaked the same way they had for 20 years. Helen's framed photograph rested on the hallway table. I paused there. Betrayal from strangers is irritating. Betrayal from family is clarifying. It reveals assumptions. It exposes entitlement. It teaches vigilance. What Ryan and Emily mistook for weakness was restraint. What they interpreted as decline was patience. Silence is not incapacity. It is observation. I protected my house. I protected my name. And I protected the lesson. Dignity is not defended loudly. It is defended precisely. My name is Thomas Harris. I am not confused. And I am not finished.